everyone. Welcome to this discussion on mediation challenges. It is a pleasure to have so many of you joining us today. For those who are new, I would like to start by saying a little bit about MediateGuru. MediateGuru is a social initiative led by members across the globe. We strive to provide you with the best lecture series from access to the best speakers across the globe so that you can add value to your legal studies and your legal career. Today, we have a brilliant panel composed of 5 fantastic mediators. I will tell you a little bit about them now, but I'm sure that you will find out a lot more later on. We have Mr. Jonathan Lux. Jonathan has over 40 years of dispute resolution experience, specialising in international and commercial law. Jonathan has been rated as a leading mediator by the Legal 500 in 2017 and by Who's Who Legal Mediation. We also have Marie Coombes, who will be speaking to us about the role that mental health can play in mediation. Marie has worked for 5 years as a full-time in-house workplace mediator, completing over 200 mediations with a 95% success rate. In 2020, Marie received the Workplace Mediator of the Year award in recognition of her excellent conduct. Next, we will hear from Nancy Radford. Nancy has been the lead mediator in over 250 mediations and is trained in civil and commercial, workplace and employment, special educational needs and disability, and international online mediation. For her work in training of mediators in online mediation, Nancy won the National Mediation Awards for Mediation Trainer in 2020. After Nancy, we will hear from Gregory Hunt. In 2016, Gregory formed Hunt ADR, which is registered with the Civil Mediation Council as a mediation and training provider. Gregory has been involved in at least 120 mediations involving both individuals and companies, ranging from no monetary value to over 30 million. Last but not least, we will have the wonderful Chris Mackin, who will speak to you all and take your questions. Chris is a chartered accountant and specialises in partnership, company, and commercial disputes. Chris has conducted well over 100 mediations with an 80% settlement rate. We would like this session to be as interactive as possible, so please do remember to ask your questions in the chat box and to answer the polls when asked. Also, you may want to grab some headphones. A part of this session is pre-recorded and it might be a little bit quieter than the rest of the event. I now request that our first speaker, Jonathan, take the session forward and enlighten us all. So Jonathan, if you'd like to come on, please.
Hello, can you hear me?
Yes, hello, we can hear you, Jonathan.
Excellent. So good afternoon, one and all, or good morning, good evening, wherever it is you may be situated. And let me start by thanking you, Phoebe, for inviting me to speak, and thank also my fellow speakers for letting me go first. That's because I'm attending the webinar in about 2 points free to raise. I think Phoebe will monitor the chat line and give me any questions you raise now. Alternatively, Phoebe can email to me afterwards any questions which you didn't have the time to put to me whilst I'm with you. As was mentioned, I practice in the area of international commercial disputes, particularly relating to shipping and international trade. Now, compared with the complicated rules of courts, the typical mediation procedure is really very simple. The first step is that the parties will agree to appoint me, or of course someone else, as mediator, and I will then send out my standard form mediation agreement to sign and return. Secondly, the parties will send to me and exchange between themselves mediation position statements, setting out the history of their relationship, the disputes which have arisen, and what each party would like to achieve from the mediation. The next step would be that the parties agree, hopefully they can agree and send me an agreed bundle of documents. The alternative is that each party simply sends to me the set of documents they choose. Then the next step is a preliminary meeting when I will speak with each of the parties and their lawyers separately. Now, since the start of coronavirus, these have all been virtual meetings using the Zoom or some other such platform. And the sort of matters I will want to discuss with each party are, firstly, who will be in attendance at the mediation hearing, which issues each attendee is there to address, and importantly, to ensure that there is a senior decision maker present who can agree settlement terms on the day and sign off on any settlement that is achieved. And finally, there will then be the main hearing or hearings themselves, which again will be attended by the parties, their lawyers, and myself. And in most cases, by the end of the mediation hearing, a settlement will have been agreed and will have been signed off by the parties. Now, I would like to tell you now about a particularly tricky preliminary meeting. So the meeting before the main hearing, and invite your views on how it would have been best to proceed before telling you what actually happened. So please do use the chat function to communicate your views, and I hope Phoebe will then be able to relay those to me before I go on to give you the conclusion. So this particular case involved Texan, from the Lone Star State of Texas in the USA, Texan cargo claimants, and on the other side were Indian ship owners. And it was a dispute relating to alleged cargo damage. So the Texans said that their cargo had been damaged on the ship, and the ship owners were defending that claim. The Texan cargo claimants attended the preliminary meeting in full force with their full litigation team of lawyers, together with the CEO, the Chief Executive Officer, the COO, the Chief Operating Officer, and the CFO, the Chief Financial Officer of the claimant company. Now, the Indian ship owners had no previous experience of mediation. They were a little nervous about the whole process, and in consequence decided to send along to the preliminary meeting simply a junior claims handler from their claims department. So that was how the rival teams looked. A big team on the claimant side, simply the junior claims handler on the defendant side. And my questions to you are these. Firstly, what prospects of success do you think there would have been for a mediation with those attendees on each side at the main hearing? And secondly, would you as mediator have simply allowed the case to proceed from preliminary meeting to main hearing? And if not, what would you have done? So perhaps I can now give you an opportunity to send your responses, set out your views in the chat line. And Phoebe, if you could then tell me when you've collected a reasonable number, what the main views seem to be, and then I'll go on and give you the conclusion.
Okay, so there's going to be a slight time lag, but yeah, so please can you write in the chat, everyone, the answers to Jonathan's questions. What are your views? You know, there's doesn't matter if it's not necessarily correct. Just any kind of views.
There is no right or wrong, Phoebe. There are different shades of grey, as is not uncommon.
So
the first, the point, the key point to factor in is that you have a very high level claimants team with many high-powered attendees, and that's on the one side, and then the defendant side, there is just a junior claims handler on his own. Could such a mediation succeed? And if not, what's to be done?
We do have quite a good response. Ajit has said that the prospects of successful mediation generally low in his view, and he said that the party is seen quite disadvantaged. Ajit has said that you should ask them to postpone and get a legal team on both sides. What's your response to that, Jonathan?
Well, cutting straight to the chase then, I have to agree absolutely with the comment received. And that's in fact what I did, namely to postpone the main mediation hearing, to urge upon both parties that it was in their joint best interests to have rough equivalence in terms of the attending teams on each side if the process was to work. And that did take a little persuasion, but the point finally was seen, and indeed then the defendants attended with a more high-powered team, and the mediation was then able to proceed. But you'll see that one of the dangers, of course, when you start interfering as mediator in that way, it would have been quite possible to get quite an adverse reaction from one or indeed even both parties, saying, well, you know, what's the mediator doing interfering in this way? We had the mediation hearing booked, we're ready to proceed. Now he's saying they need to reorganize things. This is going to take more time. Can we be bothered with all this? Shall we not just go straight back to court and call it a day? So, you know, it's, as I say, it's not a simple definitely this or definitely that. One needs to weigh up the factors carefully. But in this case, I thought that a mediation with that constellation was almost foredoomed, and therefore that there was no real alternative but to push hard for the reorganization that took place.
We do have one more response. Someone has said that they would advise the defendant's representatives to inform their head office about the heavy representation of the plaintiffs. And if they ask to go on, trust the fairness of the mediator.
Okay, but that's an interesting one. But the mediator, of course, doesn't decide anything. The mediator is there as a facilitator. And one of the problems, I guess, is that the junior claims handler, almost by definition, will not have that power to decide anything. And therefore, however eloquent the claimant's team may be, they're preaching to a party who can't actually deliver. So, yes, the mediator must be fair, but I don't think the mediator's fairness would have resolved the problem of, the huge inequality in terms of the strength of each team.
Thank you, Jonathan. Someone else has just written, like, if the parties do not come to a settlement, the mediator should try to bring some kind of middle ground to bring a settlement between the parties. I think that's probably what you'd be aiming to do as the mediator, isn't it, if you were going to proceed with the mediation?
Well, it's, of course, the mediator in facilitating, at least the view I take is it's not a passive role. So, yes, the mediator is there to, as I see it, act as devil's advocate, to test propositions and to perhaps, in a sense, open a party's eyes to potential weaknesses of a position put forward, and hopefully from that flows a new open-mindedness to other possibilities than those initially carried into the mediation day.
Okay, thank you so much, Jonathan. I think we're going to hand over to Marie next, because otherwise we're going to have too much to fit in. But thank you so much for your time today.
Pleasure to be with you, and I'll now sign off if that's okay. But please feel free to take me up on the offer if you want to email. If others have comments or questions, that's fine. Good, thank you.
Thank you, Jonathan. Can we have Marie? Oh, there she is.
Hi. Hi, Phoebe.
Hi, Marie. Hang on. There we go.
Good afternoon, everyone, and thank you from me as well, Phoebe, for inviting myself and my fellow panelists on today. So mine's going to be a slightly different, from a slightly different angle, because I'm not a lawyer. Basically, my background is workplace mediation. So I have worked in mediation now since 2014. I started as an in-house mediator working for an organisation called Royal Mail in the UK. I'm now self-employed. I work for We Restore Calm. It's my own business, and I focus on conflict prevention and resolution, as well as training in terms of mental health first aid and mental health awareness. So it's going to be a slightly different angle that I'm going to look at for my session. So I'm going to read through two scenarios in a second. So these are two live scenarios, or two real scenarios, in terms of mediations that I have delivered. So just to explain a little bit in terms of why I'm focusing on mental health, something that I'm hugely, hugely passionate about. Okay, so mental health, I've struggled with my own mental health for a number of years, and I talk on other topics regarding my mental health and mental well-being, but also I'm very, very keen in mediation to make sure that people's voices are heard. That's a key thing for me for people that are struggling with mental health conditions. So Phoebe, if you're ready for the polls in a second, the first scenario that I'm going to touch on, it's essentially just one question for both scenarios. And that question is, would you proceed with the mediation in these cases? Okay, and it's a yes, no, maybe answer. If you put maybe, I would appreciate understanding why you think it's a maybe. Okay. So when you're ready, Phoebe, I'm going to read the first scenario. So the first scenario is, in the pre-meeting, one party discloses that they have just started taking antidepressant medication, the side effects of which have resulted in them arriving late to work on a regular basis due to oversleeping as well as struggling to concentrate. They don't want the other party to know. The other party is annoyed due to several deadlines being missed in the last few weeks.
Okay, so you should be able to see the poll, everyone. Would you proceed with the mediation in this case? Okay, we'll just leave a couple of seconds for people to finish answering.
Yeah, no problem. It's a lot of yeses, which is good to see.
There is a lot of yeses. Oh, you can see it too, Marie. That's good.
Yeah.
Yeah, 76% yes at the moment. Some have put maybe. Have we got any answers in the chat? Ajit has said no due to the risk of party breaking down. I think it's crucial to look at some of the mental factors of the mental health factors clients come to mediate.
Absolutely. Okay, so I'll pick up on the risk to breakdown after I talk about the second scenario, because I'm going to talk about each scenario in turn. So the second scenario, you're advised prior to mediation that one party suffers from severe depression and anxiety. This makes them quick to anger, and their behaviour has been described as irrational in several complaints made against this party, which are to be discussed in the mediation. Party 2 is their line manager and has told Party 1 in a recent performance review the behaviour must stop or they will be out of a job. They have also raised concerns to you of how useful mediation would be based on the other party's behaviours. So
Okay.
again, a yes.
Yes again. Can you see? Does anyone want to write anything in the chat? Few people have put maybe. Can you explain a bit more, please? Assess voluntariness, self-determination, and competence to handle the requirements of the process. That's a good answer from Susan.
Yeah, great answer. Great answer.
Ajit has put, do you mean separating the parties into different rooms, Ajit? What do you mean by that?
I will just point out workplace mediation is very different from other types of mediation in the sense of we start off with individual meetings with both parties before I even think about bringing individuals into the room together. So it is different from some legal types of mediation. Yeah, so to answer Ajit's statement, yeah, I would speak to them individually first. Absolutely, absolutely. So for me to just move on to those individual situations then, in both cases, I would not hesitate to mediate. And there are two reasons for this. Firstly, as a workplace mediator, I am the guardian of that process. So it's up to me how that mediation process is managed. And the process needs to fit the needs of the parties, regardless of any conditions they are bringing into the room, whether it be a disability, physical disability, whether it be a mental health concern. It needs to fit the needs of the parties so that they can be allowed to speak openly and honestly. Secondly, there is a very strong relationship between conflict and emotional and mental well-being. An often destructive conflict can make a mental health condition far, far worse. So in scenario 1, I talked about one party having a couple of issues bringing to the room. They were on antidepressants and the side effects were causing those issues. So where I work in sort of workplace mediation, the idea of reasonable adjustments, so making adjustments to somebody's workplace or working hours or working contract to allow them to engage properly when they are suffering from some form of disability. Those reasonable adjustments are very normal. And mediation as a process should be no different. So at all times, it should be empowering and inclusive. In the first scenario, I mentioned the party has two issues, that they oversleep and they have poor concentration. So I have that conversation individually with party one first. And what I'm doing is exactly what I would do when I'm talking about any other issues they bring into the room. I'm exploring that condition. I'm exploring it in a safe way to find out the impact their condition may have on the success of the mediation and how best to adapt the process to give them the best chance of engaging appropriately. There is always a concern for me that somebody may struggle in that mediation. So I think somebody did mention in the chat around the risk of breakdown. That is always at the back of my mind. And at all times, the safety, the emotional safety of the parties is at the forefront of my mind. Okay, so even though I say I would continue with the mediation, I always have that in the back of my mind. So in this particular discussion, party one said that mornings were difficult for them. Struggle to wake up in the morning. From a personal point of view, antidepressants are very, very difficult to wake up from. You feel groggy, you have brain fog. It's a struggle to think clearly. But they did find that in an afternoon, their head seemed to clear a bit. They felt more awake and better able to concentrate. So off the back of that, I set up the mediation so that instead of it being done as a full day, which workplace mediation often is, I did it in two halves. So I did the individual meetings on day one and the joint meeting on day two, but both in the afternoon. That gives both parties the best chance of being able to engage. Now, of course, I didn't breach confidentiality, so I didn't share with the other party why we were doing it on two afternoons. But what I did do was make it very clear what the benefits would be for both parties and in the pursuit of an agreement. What I found in that particular situation, that the chance to think overnight about what the discussion, how the discussion had gone with me, giving them overnight actually helped things enormously in that joint meeting. They were able to think about what they wanted from the mediation, and particularly party one with the concentration problems. It gave them that space to think clearly. So it worked really well, and the parties reached a good outcome to the point that during the second session, party one, despite telling me in the individual meetings they didn't want to share that they were on antidepressants, they freely shared this in the joint meeting. And that was because they felt in a position where they were empowered to say what they needed to say. This particular mediation was done at a very, very senior level at Royal Mail. It was between a senior manager and a senior union representative. And that agreement paved the way not only for the dispute between the two of them to resolve things, dispute that had gone on for several months affecting everyone. It was also having a wider ranging effect on the business. So because I was able to support them both to engage properly and bring the mediation to a satisfactory close, it actually had quite a huge impact on more than just the two people involved. When I did a follow-up call with both the parties later on, party one was really vocal on how much support he had received from the other party since that mediation. So it had a huge, huge impact on their relationship. In the second scenario, we start to see something that I call destructive conflict in action. We're seeing ultimatums. They're not listening to each other. They're undermining each other. We also start to see that conflict has a cause and effect relationship with mental health. It exacerbates the symptoms of those with a pre-existing condition. So in the first example and in this example, both have got pre-existing conditions, and the conflict with the manager was exacerbating that condition. It can also be a trigger to an issue developing. And I'll talk a little bit more about that in a second. So in this particular scenario, on speaking to party one, they revealed that whilst they had suffered from depression and anxiety for many years, the situation with their manager had made things significantly worse. So it exacerbated their condition. They were starting to blame other people. They recognized they were blaming other people in an inappropriate way, but they couldn't help themselves because of their condition. And they were lashing out, missing deadlines, and feeling constantly negative. These were the exact same issues raised by the second party in their session. And they also talked about how the situation had resulted in increased stress levels for them. So in that particular situation, we're seeing both a pre-existing condition made worse and somebody with no mental health concerns being put in a position where they're starting to develop increased stress levels. And stress is the gateway to more serious mental health conditions. So in this particular scenario, and in all mediations where mental health is a concern, for both parties, mediation was their chance to help restore something called psychological safety. And psychological safety is about feeling able to bring your whole self, emotionally, mentally, as well as physically, to any situation without fear. And the core principles of psychological safety are very closely linked to the core principles of mediation. The first one is self-determination, having control over a given situation, having control over what happens to them, having a good reputation, so knowing that they are respected, and also being in a situation where they can respect themselves as well. Fairness, we're all looking to be treated fairly in life. You know, we don't want to feel that we are being disadvantaged at any point. So fairness is a huge part of psychological safety. Being able to trust those people around you is a huge thing. In both the scenarios I've talked about, trust was severely damaged. And finally, something called the frame of reference. So frame of reference is talked about quite a lot in terms of mental health. It's the lens through which you see the world. It fuels your perception. And as I said, these sit quite closely alongside the principles of mediation, self-determined being one of the key ones. So through mediation, both parties have a chance to take back control, rebuild their reputation with each other and with the wider team, and start to rebuild trust in each other. And the outcome of that mediation was a clearer understanding of each other. And whilst party two had limited experience of mental health conditions, by allowing party one to speak, by me encouraging him to give mediation a go, he appreciated the situation party one was in, and they were able to move forward. When I followed up in the coming months, party one said their symptoms had significantly reduced as a result of the action plan that both parties made in mediation. So psychological safety was restored. So mediation, just to close, mediation is about empowerment and inclusion. Just because a party has a mental health condition, this does not preclude them from entering in mediation. And it was great to see on the poll at the beginning that there were a lot of people that would have continued with the mediation. As guardians of the process, regardless of whether you're a workplace mediator, a lawyer, whatever type of mediation you are doing, we must ensure every effort is made so that both parties can engage. And just as a final note, I used the phrase destructive conflict earlier. This is because despite everything, conflict is not inherently bad. And that's something that's quite difficult for some people to wrap their head around. Conflict just is, and it's completely unavoidable. And that's because we all have a different frame of reference. We all come from a different background. We all have different education. We all come from different cultures. So we all look at the world in different ways. Timothy Clark, in his book on the 4 stages of psychological safety, refers to the opposite of destructive conflict as intellectual friction, as it generates ideas and innovation. I term it constructive conflict. Mediation is often about resolving an issue. However, it also gives people a safe space to see how constructive conflict works, thereby encouraging a psychologically safe environment for them when they meet in the future.
Thank you so much, Marie. That was such a good insight into an interesting area of mediation, or a concept which probably not many of us have thought that much about before. If any of you would like to learn more about mental health and mediation, Marie is going to be doing an event with us on her own, a longer one in October. So just keep a lookout for that. So thank you, Marie. I think we're going to pass over to Nancy now so that we don't run over too much.
Yeah, no problem. Thank you, Phoebe.
Thank you so much. Hi, Nancy.
Hi. So can you hear me okay?
Yeah, we can hear you.
That's great.
I'll just make you a bit bigger. There you go.
Thanks. That's super. So like Marie, I also do workplace mediations, but today I'm going to talk about some of the different mediations. Unlike Jonathan, most of the clients I work with are not with their lawyers when they come to mediation. Sometimes they've had legal advice. I always advise them to get legal advice. But generally, I offer help with personality clashes, awkward customers, late payment, director disagreements, family disputes, and I specialize mainly in small business, individuals, the care sector, charities, and social enterprises. And I'm also qualified to work with vulnerable and emotional clients, and I work with special educational needs mediations where parents and local authorities are disagreeing. So today, I want you to sort of think about whether mediation is actually always the best thing, and whether what the problem is in an issue. So what I'm going to do is give a little scenario of which is, based on true cases that have come to me. And then we'll ask you, is mediation the way forward? And what are the other options? So the first case was a father and a daughter. I was first contacted by the daughter's lawyer because the daughter wanted to go to mediation and they were having difficulties with connecting with the father. And the lawyer wasn't sure whether the father was genuine in the desire to mediate and was concerned about the daughter. The daughter had paid off the father's debt. She'd worked with the father in a family business for a long time. And he'd ended up in, it was a long and complicated story. However, the daughter thought that the father had given her the house that she was living in. She'd lived in it and improved it for 10 years. But the father now wanted her to move out and to pay him back rent for 10 years. And the lawyer was concerned whether mediation was appropriate or not. The daughter wanted to pay the father the full going price, but the father just wanted her out of the house and wanted to claim the back rent. So what are the options here? Do you want to do the poll, Phoebe, again?
Would you like me to just do...
Yeah, the yes, no, maybe,
yes, no,
and the answers in the quotes. So if
would you proceed with the mediation in this case?
Yeah, or if not, what else would you do?
Okay, so I've put up the poll, would you proceed? And if not, what else would you do? You can write your answers in the chat. Got some responses coming in. Most people are saying that yes, they would proceed. Does anyone have any thoughts in the chat? We've got the overwhelming majority saying yes.
That's quite interesting because in this case, as a mediator, I always try and make myself redundant as a mediator by looking at other options that enable people to resolve stuff themselves. So in this situation, what the two parties decided to do was to have an initial, I do what we call staggered mediation or a phase 1 mediation. where the parties, particularly for parties who don't necessarily want to mediate, to just listen to them talk through the options of mediation and what other options there were. In this case, the father was determined to go to court. The daughter really was upset. There were indications because I talked to each person individually. So we had kind of a conflict, a coaching session. And there were indications that the daughter would have been very much frightened of her father and just given in to everything. And there was some indications to me that there was perhaps some abuse going on. So I asked the daughter what she wanted to do. She was actually quite concerned about meeting with her father, even online. So in that case, both the daughter and the father came up with something that their lawyers could exchange terms, and that if that didn't work, they would go to court. So I basically made myself redundant, but it actually was the best in that situation. In other situations, it might be different. Another situation, how much time have I got, Phoebe? I was going to do 3 if I have time.
That's fine, we can do them. We might run over a tiny bit already, but it's okay.
Okay. So I'll go in because I noticed there was a question. I'll skip the second one. In this case, we were in a mediation, and it was with parents, a school, and a local authority. The local authority was refusing something that the parents in the school felt was needed. And the representative from the school became very angry and started shouting. So I guess in this situation, just put in the chat, what would you do?
Okay, any ideas? There is a slight delay. What would you do? One party's becoming very angry. We've got some responses in regards to the previous situation.
Yeah, I can see that.
Someone's asked, would the power imbalance between the father and daughter make the mediation inappropriate?
I think it means that you have to be careful, because really in mediation, what you want is people, as Marie said, to feel safe, because if people don't feel safe, they get angry, they get frightened, their brain, and when you're angry or frightened, your brain stops working properly. So you make decisions which you may regret. And if you have that situation in mediation, even if people ask you at the time, is this really what you want to do? You're not thinking straight. So this is why I often do staggered mediations. So I have first sessions so people have time to think about it. And I try and do what I know a lot of you have been to Kathleen Leedy's sessions, and she says the role of the mediator is not, it's kind of, mediation's like a journey, and it's not up to the mediator to say, I think you need to settle, or I think you need to go that way. The mediator is like the engineer in your spaceship. It's keeping the ship steady, keeping it safe. Yeah, it's not about saying, do this or do that.
We do have some responses to the second situation now.
Oh, yes, they're getting...
said, I'm from Yorkshire. I would shout back, a brisk approach is expected. Another one of our students, though, has said, separate the parties into different rooms.
Yeah, and all of those things actually could work, right? apart from sort of putting your hand over somebody's mouth. It really depends on your reading of the situation. You know, is someone shouting and angry because they're upset? And sometimes it's helpful for other people to see how upset they are. It's looking at how is it affecting the other people in the mediation. Is it something that if someone has an emotional outburst, is that helping the other person understand? Or is that making the other person defensive and angry? And so it's mediation's really an art rather than a science. And the more you do it, the more you observe people. But I always like to have individual sessions with people beforehand so they understand mediation, that if someone is looking upset, they can send me a private message, they can ask. And I always say at the beginning of the mediation, we're here to figure out what the issue is. And it's about helping them, first of all, realize what the issue is. So have we got time? And I'll just tell you about a situation or not?
We can quickly.
Okay. So this was a situation where two sisters, one lived abroad, mom had dementia and was living alone, but in emergency, the sister who lived in the UK had to find her a place in a nursing home. And she was there for a couple of years. She wasn't very happy, but what she really wanted to do was go home. And everybody agreed there wasn't facilities for her to do so. When the abroad sister came to visit, she was very unhappy and wanted mum to be moved to a much nicer nursing home. Sister who lived in UK felt very resentful that her sister had dropped in and was making all these complaints. Sister from abroad wanted the mum to be involved in the mediation and didn't, but the other sister, didn't want mediation, didn't think that it was good for mum because it would upset her. So they thought the issue was about where mum lived. Yeah, that wasn't the issue. The issue was what the mother's mental capacity, because both of them actually agreed that the new home would be much better, but they disagreed about how that would affect their mother. And mediation, and we got to this stage with separate sessions, and mediation in that case, we would be talking about two different problems. So what they decided to do was actually to get an assessment of the mother and to get professionals in to say what would be the best solution for mom. Yeah, so that was mediation, but in a different sort of way. So yeah, so you can't solve a problem from the same consciousness that created it. You need to sort of look at it from different angles. Okay, because sometimes people just see their solutions. They don't actually work out what the problem is. And that's what I think the mediator's role is, to find out the problems.
Thank you so much, Nancy. That's been a really good, insightful session. I think we need to press on, but if you'd ever like to come back, do let me know. Do get in touch.
Thanks.
Okay, so next we actually have a pre-recorded section. This is from Gregory Hunt. If you don't have headphones, you might just want to grab some, pop them in. This will be a little bit quieter than the rest of the event, but it is audible. So I'm just going to put that on now.
Hi, my name is Greg Hunt, and I'm the founder and chief executive of Untitled Limited, based in the UK. I'd like to thank MediateGuru for giving me the opportunity to speak to you today. I'm sorry I can't be there in person, so we thought the next best thing was to record a video for you. I'm going to look at some problems and challenges in a couple of mediations that I've been involved in, and then give you the opportunity to have a think about what maybe the solution was. Okay, I'm going to show you some slides now. Okay, so as I said, I'm going to run through a couple of examples of mediations that I've been involved with that needed a little bit of thought. Just to give you a bit more background first about Hunt ADR, I founded Hunt ADR back in April 2016 after working in mediation, arbitration and ombudsman services in the UK for around 20 years. I'm a fellow of the Civil Mediation Council, experienced mediator and a certified mediator skills trainer. So we also provide mediator skills training online, in person, however you want to do it. We appoint mediators, we appoint arbitrators, and we provide CPD training and events for arbitrators and mediators as well. Okay, so that's enough about Hunt ADR. So just when I was asked to do this, I was thinking, well, I've been quite fortunate, I think, in that I don't really think off the top of my head about too many problems I've had at mediation. I tend to just work through them with the parties. So I thought, well, not all mediation problems are complex. Some of them are quite simple to deal with. Some, if not most, if not all of them, are actually down to personalities of the people involved in the mediation. So if you can communicate with people, you can get over those problems. And I believe the most important skill set that a mediator has is their ability to communicate with people, whether they are individuals as part of groups or teams within the mediation, or when you've got everybody in the same room, all the parties are together with the mediator as well. The following two examples I'm going to give you are real. They're real cases that I mediated in. They are not hugely complex. I've only got 7.5 minutes to tell you about them and then the solution. But they are typical of types of issues that a mediator has to deal with that maybe you don't get taught when you're on training courses. And one of them in particular happened before the mediation even took place, and so it was really down to the mediator to actually sort of sort that out before the mediation happened. Yeah, in each case, the mediation and the resolution of the disputes were vital to the parties and could only be resolved by clear, concise, controlled communication. Okay, and as I said a minute or so ago, I believe that the most important skill set that a mediator should have is being able to communicate with people. And it doesn't matter whether that is a litigant in person or the chief executive of a multinational corporation. Your role as a mediator is to be able to communicate and to help them communicate and negotiate with each other. And so if you can't actually communicate yourself, then you need to work on those skills and improve them before you start mediating. So the first problem I call the monocled mediator, which will be obvious as why when we go through. I also call it tenacious mediator. I always remember when I was first trained as a mediator, one of the coaches said to me, "Greg, you're very tenacious, and that's what we like to see in a mediator. You just don't give up. You keep on trying to find out ways to work with the parties and help them to come to a solution." For this particular problem, there was a dispute over quality of work on a domestic extension. It was worth a claim of about £30,000. The mediation took place about 200 miles from the mediator's home. I was the mediator, so I had to travel 400-mile round trip for the mediation to take place. Despite many attempts, and I mean many, to make contact with the defendant, this had gone to court and been referred to mediation, there was no contact between me and the defendant. Okay, so also the claimant solicitor was trying to get in touch with the defendant and couldn't as well. So the afternoon before the mediation was scheduled, I and the claimant and her lawyers were not sure if the mediation was going to go ahead because we just could not contact the other party. So as the mediator, I'm left thinking, am I wasting my time here? Am I wasting my money? I've booked a hotel, I've booked a train, I'm going to have to pay for meals, breakfast, lunch, dinner, etc., and so on. So what do I do? What are my options going forward? Mediation, 400-mile round trip. one of the parties looks like they're not going to turn up. So do I turn up? Do I suggest to the claimant that we don't go ahead? What do I do? What are my options? Okay, so that's the first problem. The second problem, which I call the wrong trousers, and again, that may come to some of you who know about Wallace and Gromit and the wrong trousers. If you don't, then you won't have a clue what I'm talking about. Okay, so the problem, dispute over quality of work renovating an old farmhouse for domestic use, and specifically about the quality of the stonework in the refurbishment of the farmhouse kitchen floor. Okay, and this claim was worth about £50,000. The parties had instructed a large city law firm each, and costs were spiralling. Okay, this was in a provincial city in the UK and not in London. Big law firms from those cities representing the parties. I had a sense that there was some fabrication of the truth and that the claim was dishonest. Just had a sense, the way the parties were talking, the engagement between them, looks from the lawyers. I just felt that there was something going on and I couldn't get to the bottom of it. So I'm left here thinking that something's wrong, and unless I find out what, the case will not settle and costs will ultimately be larger than the amount in dispute. So what do I do?
Okay, so unfortunately we don't have Greg here, but I will play the solutions next that Greg has provided. Chris has said in the chat, I would ask the claimant lawyer if they will underwrite my fees so that it can take place if the defendant does turn up, and if the claimant can put those wasted costs in the cost schedule after the trial. So very good answer there from Chris. Thank you, Chris. I'll play what Greg has prepared next.
Okay, so you've now had some time to consider what I may have done in those two scenarios that I gave to you. So now we're going to look at what I actually did. So let's start with a quote from the late great John Lennon. There are no problems, only solutions. So we have problems. How is it going to deal with them? However they were dealt with, we're going to be the solution. So the monocled mediator, the solution. Remember, I couldn't get in touch. We didn't know if the mediation was going to take place. So I decided to catch him off guard and phone at an unexpected time. Okay, so I called the mediator about 8:30, 9 o'clock not the mediator, I'm the mediator. I called the defendant about 8:30, 9 o'clock at evening. They weren't expecting my call. They didn't have voice recognition, number recognition on the phone. So when I was calling and he answered, caught him slightly off guard. Hello, Mr. Smith. I'm Greg. I'm your mediator for your dispute tomorrow morning. Because, of course, this was the night before the mediation. I had the opportunity to answer some questions or fears that the defendant had, and we went ahead with the mediation, and it ultimately settled. So some of his fears, he thought that I would be a judge in a full gown with a wig and a monocle, very posh from London, and I'd be telling him what to do. So I explained to him, well, first of all, I don't wear a wig, although I am bald. I maybe do with sometimes. I don't wear a monocle, and I won't be telling him what to do. That's not my role. I had travelled by that point because I had to take a gamble that the mediation was going to go ahead. And I'd travelled down in a suit, but I'd said to him, well, I'll take my tie off, and I won't wear the jacket, so I'll just be in a pair of trousers and a shirt. I'm sure the other party will be in sort of business casual. The claimant was a homeowner, so probably wasn't going to turn up in a suit or anything like that as well. And I certainly won't be telling you what to do. And I explained to him at that point what mediation was. So important to do this with parties, particularly litigants in person. I explained what mediation was, what the process was going to be, and how my role was there to try and facilitate resolution between the two of them and not come up with some solution that he had no option but to accept. So about the clothing there, he said, well, I'm just, I've got plastering work on, and I want to be able to go straight to a job after I've finished the mediation. And in order to do that, I'm just going to have to be wearing my shorts and a t-shirt, and I may even have some of my gear with me for the plastering as well. So I said, well, that's fine. You know, again, it doesn't matter what you wear. I'd rather you were there. I don't care what you wear as long as you turn up. And then he thought he's going to lose out on some paid work in the afternoon because of the mediation. So we had a conversation then about the fact, well, you've got £30,000 claim against you at the moment. And, you know, that could include some more money in relation to costs. So if your job tomorrow afternoon is worth more than £30,000, then, you know, that's a calculated gamble you might want to take. If it's worth a few £100s, then just think about the bigger picture and what you might lose ultimately if you don't go to the mediation and the judge finds against you when you go to court. I also took the opportunity, because of course he hadn't read any of the paperwork properly or anything like that, because he was automatically, no, I'm not going to do this. I explained to him that it was a time-limited mediation. It was from 9:30 till 12:30. So actually, he could wear what he wanted. He could be there in the knowledge that I wasn't some posh person from London. I'm a normal person, happens to be from the northwest of England, near Liverpool. And I wouldn't be in a expensive suit or whatever. I wouldn't even be wearing a tie. And he can wear what he likes, and he can even leave at 12:30 or before, if we manage to get settlement earlier, and go and do his work in the afternoon, so not lose out at all. So he explained actually that his work in the afternoon started at 2 o'clock. It was a small plastering job, but he needs the money, which is of course fair enough. And so as long as he could just come in his gear, he'd be fine. So we agreed all that. He said he'd come the next morning. He turned up. He did have a t-shirt on with plastered all over it, pair of shorts, pair of hard steel toe cap boots. And we did the mediation, and it settled by about 12 o'clock, and the parties were able to go. Now, the key here, remembering the initial problem, we didn't even know if the mediation was going to take place. So it's really important that as a mediator, you try and speak to the parties before the mediation. If one of the parties has not got legal representation, then this is even more likely to be the case. They may be fearful of what they're entering into. They may not understand what they're entering into. So part of your role is to put them at ease before the mediation, to help them to then take part and ultimately try and get some sort of resolution. So if you remember the wrong trousers, the dispute over a farmhouse floor in particular, what was the solution? Okay, so I continued with the mediation, even though I thought something was a little bit awry, because I had a plan. And that plan, it was very important. I always try and build really good rapport with the parties. It's very important for a mediator to build a good relationship in order to help the parties to then want to open up. But I really wanted to do it in this case. So I spent a good hour furthering that rapport with them and their legal teams, because I wanted to take a punt. So I wanted to take a chance and ask the lawyers if I could speak to their clients without the lawyers being present in the room. Okay, now most lawyers, in my experience, I would guess, because it doesn't happen very often, but I would guess would say no. But fortunately, both legal teams said, yes, that's okay. You can speak to our clients without us present. So lawyers left. I asked the parties what was really going on. And a huge lie unraveled in front of me, which totally changed the course of the mediation. What transpired was that the claimant and the defendant lived in a small village in a rural county in England, and the mother of the claimant hated the mother of the defendant. So she made her son, a grown man, she made her son fabricate a whole lie about the quality of workmanship in the refurbishment of the farmhouse floor, and to actually start a court case. So it was all a lie. The reason they did that is because she wanted revenge on the mother of the defendant. And she thought, if I can get her son's business closed down or really bad reputation locally, she will then suffer as a result of that. So it was all a lie. There was no case to answer. This whole mediation took place. I was paid quite a nice, handsome fee. the lawyers were getting paid quite a nice handsome fee for something that was completely fabricated. So I just thought, well, one more thing I could possibly do here. I asked the parties if their mothers were in that city that day, because I thought, well, if they're the sort of mothers who've gone to this extent, there's a good chance that they've come to the city today. And they had. And they were both out just shopping. It's a big city by England standards. And they were both shopping in the city. So I got them to phone the mums and to say, can you come to the law office, please? We want you to take part in the mediation. I got the lawyers to agree. And then we had a fresh mediation where we had the original parties, their lawyers, and also the two now principals, the mothers. And what we did is we got the defendant's mother into a position where she was prepared to tell her son to drop the claim. You know, no more claim, and going forward to apologise, and for the two mothers to agree they would never say anything about this, and if they passed each other in the street in their small village, then they would just nod, maybe say hello, but not have any more relationship than that. And this was drafted up into a mediated settlement agreement, and the dispute ended. So, I mean, that was a bit of an unusual one for me and a bit of a challenge at times. So first of all, I have to go through the process of the suspicion that something wasn't right, then sort of building a good rapport with the parties and their lawyers to try and get into a position where we could just have a meeting with the parties, then to get the parties to open up and admit that the whole thing was fabricated, then to have the luck, in effect, that the mothers were in the city on the day, then to be able to get to the mothers into the mediation, and then to get them to agree to a settlement to end the dispute. Okay, so I hope you've found those two examples of interest. It's always really difficult to do a short presentation. I find it easier to do longer ones. So I just thought there's two relatively simple, in essence, relatively simple issues there that were dealt with. One was before the mediation even took place, and the other one was actually finding out the parties were just fabricating the case, and we needed the right people there. So I hope you've enjoyed this short presentation. If you'd like to do some more with us, we do have an offer on at the moment for MediateGuru students. You can see down there the link to our new e-learning portal, literally launched today. If you select Cert IDR, then you get 10% discount for the first 50 students who sign up. And this takes you through about 14 videos on mediation and arbitration by myself, and also Rika Rangachari and Dr. Kabir Degal, and we hope that you'd enjoy them as well. Okay, so thank you very much, and I'm sure if you've got any questions.
Okay, hopefully you all got something from that, and thank you to everyone who's been leaving your questions in the chat. Chris is now going to come on and we will have those questions answered for you. So Chris, are you there, please? Can you put your camera on and your microphone? Oh, there you go. Wonderful.
Hello, Phoebe. Hello, everybody. Well, I've learned quite a lot so far. I hope everybody else has. I'm just here to share experiences, and I've had quite a few. So bring on your questions. Let's see what happens.
We do have a few questions. So one of the questions asked right at the start was, what do you do when parties are being faced with a brick wall? Like, how would you handle a case where one party is very adamant that they won't mediate?
They've got a dispute. It has to be settled. Something has to happen. They have taken the trouble to come along to a mediation, and I would ask them why they've taken all that trouble if they're now going to waste the opportunity of talking matters through and hopefully reaching a resolution. Because the alternative, after they've taken all that trouble, would undoubtedly be a very expensive court action. So why did you take all this trouble to get here if you're not prepared to talk about things? Let's be honest with each other. we'll be in separate rooms. You can tell me anything you want, anything at all. And you've already had my promise at the joint meeting at the beginning that I am not going to share anything with anybody else except with your express permission. So we are people of the world. We understand matters. Talk to me, and together we'll decide how much of that we should pass to the other side. But don't waste this opportunity of talking about matters now we've got together.
Well said, Chris. Thank you. It's important to remember there's a dispute at hand, and everyone ideally wants the same thing to settle it, I suppose, whether that be through mediation or another method. We do have some more questions. So a lot of our viewers are students. Someone has asked, as a beginner, do you have any advice for what kind of skills I need to use in a mediation?
Right, I'll say two things. Greg has told you all about his website, so I'll give you mine. It's very, very straightforward. chrismaking.co.uk www.chrismaking.co.uk. And I have three parts to my career. I'm mainly a forensic accountant. I also do mediations and I do expert determinations. And there's a section on each of those on the and each of them has got videos where I explain what I do. The mediation section really has become a textbook on how to do mediations. As well as the video, I've got previous presentations I've done, including some to Mediator Network, who asked me to, along and introduced me to you, Phoebe, and frequently asked questions, how to prepare, what happens on the day, all that sort of thing is covered. So if you take the trouble to look at the mediation page, you don't need to know anything more than I've already posted there.
Okay, thank you for that, Chris. We've had some discussion in the chat already about mediating in different settings. Would you, in your experience, say that it's helpful to mediate in a more casual setting? Would that help the parties a little bit?
As with so many things, it depends. Greg Hunt has said that he was always prepared to take his jacket and his tie off, or even appear in jeans. And he talked about one of the parties being a plasterer who came in his work clothes in the morning so that he could go to work in the afternoon. That's fine, because I would do something very, very similar. I tend to get properly dressed at the start of a mediation with a tie and a suit, but my jacket never lasts more than 20 minutes. It'll be on the back of a chair and the tie doesn't last much longer. But if I were in the City of London firm, and I've mediated in some of these wonderfully palatial offices where everybody sits to attention with their best Sunday clothes on, I would dress the same. The mediator is a chameleon. We have to change our colour to suit the people we are dealing with. Simple as that. Just think about how the parties are likely to be dressed and dress accordingly. And if you get it wrong, it doesn't matter. Because, you know, one of the things I find so fascinating is this. I'm often chosen as a mediator because I'm a chartered accountant. So people think I know all about finance, annual accounts, audits, professional negligence of accountants, all that sort of thing. But I've done boundary disputes. I've done cars that burst into flames. I've done defamation. I've done all sorts of things, because what the parties need far, far more than the mediator's professional background is that the mediator listens. One mouth and two ears is the correct combination. And more than skilled professionals as mediator, the parties need really a social worker, which gets to the core of mediation. We've had a few examples today where it's been clear that the dispute was nothing to do with what was officially in the paperwork. That happens all the time. Two things I want to say about that. One of them is, by all means, prepare. When you get the paperwork, you've got to read it. Although I do detest the solicitors who photocopy everything that's in their filing cabinet and send me 3 ring binders and say, sort it out from that. I don't want to know. I want one sheet of paper. This is what it's about. You always get a few sheets, but you don't want a filing cabinet full. But on the day, as you listen carefully, the dispute is virtually never about what officially it was about. Okay, that's the first thing I will say. So listen very, very carefully and pick up on what you learn, and that will be inevitably the solution. And the other thing I would say very briefly is look for the gold dust. If there is something which one party wants more than anything in the world, and it costs the other party nothing to give away, there's your answer. I once did a really nasty probate mediation up in Newcastle upon Tyne between a brother and a sister who hated each other for a passion. The solution was that the brother wanted the family grandfather clock. And the sister just didn't care. She said, oh, give it him, it'll be right. That was the solution, and everything else melted away. Gold dust, very important. It's fun.
Oh, thank you, Chris. Someone said that you're the best speaker that they've seen. You're someone's favourite.
Well, as you know, I prepared absolutely nothing. You asked us all to make preparation, and I said, no chance. I was on holiday till yesterday. So I didn't think about it at all. I can just, I'll take whatever questions are thrown at me.
Okay. Someone's asked, when you do have a party that is being quite reluctant to mediate, when can mandatory mediation come into play? I think sometimes there are kind of rules around mediation out there, can get penalties in court sometimes.
Yep. Right. I can only talk in terms of English law, English and Welsh law, because I've never done any mediations in any other country. And it's interesting how mandatory mediation has developed in English law. The fact is we don't have it, but we have a number of encouragements. One of them is a Court of Appeal decision called Halsey, Halsey, against Milton Keynes NHS Trust, where there was a checklist given by one of the judges on what would be reasonable reasons for refusing to mediate, and they are very, very few. And if a party is invited to mediate and they refuse, then unless the reasons for refusal fit into that very short list, they are at risk of having to pay the legal costs of both sides, whether or not they win at trial. So that's a fairly fierce situation that one needs to address. I'm only talking about civil and commercial cases because, again, that's my experience. I don't do workplace, family, etc. mediation. But we are getting more and more encouragement from judges. For instance, some judges insist that when that refusal is given, the parties refusing have to produce a witness statement which is not revealed to anyone until the costs of the case are considered afterwards. So there's a contemporary explanation of their reasons to refuse, but it has to be a jolly good one if they are going to avoid having to pay a lot of legal costs. Still a lot of debate in England about mediations being mandatory. It's a wonderful process, and you can always have your trial if it fails. You don't lose any of your legal rights, and it's all confidential. And all you have to do when applying for a trial is tick a box to say, we've had a mediation. The judge, who knows nothing at all about what was discussed at the mediation, nor will he ever know. but it's all part of a gradual process of persuading or even bullying the parties to mediate. And if you want to laugh, look on my website under the blogs. I've got one which is called The Bon Mot of Sir Alan. Sir Alan Ward is a retired Court of Appeal judge. I know him, I've mediated with him, and he was notorious for two things. On the bench, he would tell a lot of jokes, and he would also be very, very strict with parties who had refused to mediate. Don't be so stupid. Why are you here? Why have you spent £100,000 on an Audi which the garage refused to take back when you said it was faulty, when the whole thing could have been restored for about £6,000? You must be mad. And please, God, do not go to the Supreme Court. So The Bon Mot of Sir Alan is quite a good blog to look for.
Thank you, Chris. I suppose it's an interesting debate, isn't it, whether mediation should be mandatory? Do you have like do you lead any particular way on that? I suppose there are pros and cons.
I know little about it, but it's said that in other countries, Italy, I believe, is one, where mediation is mandatory, and when it makes no difference to the proportion of mediations which are successful. You would think that a party which doesn't want to mediate, but is obliged to do so, would be far less likely to settle at mediation than parties who go to mediation willingly. In fact, it tends to make little difference. I understand, but I don't know a lot about it. I'm content with the judicial pressure that we're getting. They've just drawn back from forcing parties to mediate, but they're making it very expensive if you don't. I think that's a good situation.
Okay, we have another question from one of our viewers. Ajit has asked, how do you mediate a fraud case? Have you had any experience of this?
You'd think that as a chartered accountant, I would have come across fraud in mediation.
Yeah, I thought it would be a good one for you.
Yeah. I deal with it all the time as an expert witness, of course, but I have never encountered it in mediation. As I put in the chat, I did have one case in East London where one of the parties asked me to go into the other room and say, "This is the name of my hitman. I will send him round to see you with his pistol unless you agree to my demands." What did I do? I had to stop the mediation because I am not getting involved in criminal acts. The difficulty was it was an accountant's professional negligence case, and the accountant himself was with his claims manager, who was being very, very helpful and was actually offering to settle this particular case for more than it was worth. She just wanted to settle the case, pay a bit extra, and get on with the next job. And when I went into the accountant's room and said, "I'm awfully sorry, it's over, I can't take things any further, and I can't tell you why," they were very, very confused. But I couldn't tell them what had happened.
That must be such a peculiar situation.
Yeah, I just had to stop it.
Yeah. Wow. Does anyone else have any more questions? We'll just leave a couple of minutes. If anyone else wants to ask anything in the chat.
There's this one about matrimonial family mediation in India. Again, I stress that I've only ever worked in English law, so I don't know the rules there. And I don't do family mediation because in England, family mediation is an entirely separate qualification, and it's done in an entirely different way. I do know that in family cases, we have a thing called MIAM, M-I-A-M, Mediation, Information and Advice Meeting, where a mediator, a family mediator, sees each of the spouses separately and assesses with them whether mediation would be helpful, and the mediator then puts in a brief report to the court on whether or not they advise mediation. You can't disclose to the judge anything that was discussed, except is it going to be helpful or not. And spouses cannot have a family trial until they have attended a MIAM. But as I've said, it's a totally different subject to my civil and commercial mediation. Can I just pick up one thing from myself, which I've got out of Nancy's presentation? She talked about a phase 1 mediation, where she meets the parties just in a preliminary way to discuss whether or not mediation would be effective. I've had exactly that situation. It was supposed to be a 2-hour mediation, simply where I discussed with the parties whether mediation would help. It was an interesting case of 3 brothers. One brother was living in a flat in London, which is valuable. The other 2 had a joint ownership, but they were dyslexic and they felt very disadvantaged in any negotiations. So we had a mediation about whether a full-blown mediation would help. The outcome of it was we decided, no, mediation would not help, and instead we would go on to expert determination. Now, that's something which isn't known by a lot of people in the legal world, but expert determination is, if you like, a simplified form of arbitration. And I am a qualified expert determiner, and the difference between mediation and expert determination is that I make the decision. I am the judge. Each side has to put their case to me. Each side has the opportunity to comment on the other side's presentation to me, just like at court. And I then make a binding decision. Again, going back to my website, there's a very extensive page on expert determination, which hopefully you will find of interest. And it's very suitable for where you don't think the parties are ever going to agree. So why waste your time on mediation and where they're heading for court with a case that might cost £100,000? They can have the same outcome on expert determination for perhaps 15 to 20,000. Well worth thinking about.
Thank you so much for that, Chris. You've really been a great help to many of our students. I think we're running short on time now, but we've had some lovely comments on your I don't know if it's a cello or a viola behind you, but
it's a double bass. It's a double bass. It's my heart. It's my real passion. I play principal double bass in the Leeds Symphony Orchestra.
Oh, it's gorgeous.
And that is a wonderful instrument. It's very valuable as well.
It looks it. It's beautiful.
Yeah.
But thank you so much for volunteering your time today. It's been so helpful. To all the other speakers as well, if you're still on the call, thank you so much for joining us today. I'm just going to say very few words before we leave. So please do fill out the attendance form today in order to receive your e-certificates, everyone. I think some of you have already. And before concluding, I'd just like to take the opportunity to introduce our International Arbitration Moot competition that's going to be hosted by MediateGuru coming up this September. The registrations are open and it will be a landmark opportunity to learn more about the practical insights of arbitration. For more information, please do visit www.mediateguru.com. And if you don't want to miss any of our updates, then please do follow us on our social media handles. We're at MediateGuru on Instagram, Facebook, Twitter, we're at Guru Mediate. But we can also add you to our WhatsApp groups if you register on our website. So thank you everyone for joining us. And I really do hope that you have a great rest of your day, whether it's evening or afternoon. I think that's all we have time for today. But thank you again, Chris. You've been brilliant.
Well, I'm now going to a barbecue, but it's raining.
Oh, oh no, it is, isn't it? It's a bit miserable outside.